Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have lawyer extraordinaire, who I have known for 14 years, Jessica Perroni.
Thanks so much for having me, Melinda.
I'm so glad you're here.
Me too. It's good to see you.
It's good to have you here. So you're lawyer extraordinaire, but in a specific area of law, what we call family law,
That's
right?
That's right.
And what all does that include?
So I can say I specialize in family law because I'm board certified, but that includes, I always explain it as anything that comes basically in the family code. And a lot of people don't really realize what that means, but mostly divorce, what I think most people would call child custody. But what does that really mean? Modifications of child custody or parenting plans. Also includes postnuptial agreements, premarital agreements. There's adoption and termination of parental rights.
Does it include wills and estates?
It does not, and that is what a lot of people, it's a great question, because a lot of people will ask me about that, and it seems like that those would certainly coincide, and a lot of the rules are very similar, but it does not. That is a separate specialty area, that's a separate code that I do not dabble in.
And tell us what firm you're with.
I'm at KoonsFuller. We've got several offices in the DFW area, but I work out of the Plano office, which is our Collin County office.
And are you all the biggest firm in Texas, the biggest family law firm?
I've heard that. I know we're one of the biggest. I have not actually counted compared to other firms, but in terms of the number of lawyers, we are pretty vast, and we offer a unique opportunity for that because there are most family law lawyers are either solo or with a smaller or medium-sized firm, and I think we do have a great advantage because we do have a lot of resources, not just lawyers, but other specialty areas as well.
You're deep,
that's right,
so to speak. I know you have a fabulous mental health professional there, but I think she's becoming a lawyer.
That's right. Yeah, she's Jenny Gomez. She's our licensed professional counselor, and I always talk about her. We have one on staff, and I say not to help with us per se, although she does probably, but she works as our consulting expert because mental health certainly does intersect a lot in family law, especially when we're dealing with kiddos and parent functioning. And she is an invaluable resource, but she is in law school.
I was
happy for her, but sad for us.
When she went to your firm because she used to be available for hire.
Exactly.
And then she went to your firm. I was like, wait a minute.
Exactly.
So I know how great she is. Well, you have a great firm, great reputation.
Thank you.
Let's talk about modifications.
Okay.
So I think most people know what a divorce is.
Sure.
It's kind of self-explanatory.
Sure.
But I think a lot of people don't know what is a modification. So what is a modification?
Okay, that's a great question. I'll start with kind of what I said earlier about what is custody.
Yes.
I have a lot of clients or friends, just people in general, who talk about custody, or they'll say, I want custody. And I always ask,
custody.
Yes. And I say, well, what does that mean to you? And I think they're kind of taken aback by that. And we're like, well, you're the lawyer. Why are you asking me? And I don't know if this is entirely true, but in the family code, I don't really think that it might ever refer to the term custody.
Oh, you're probably right.
Specifically, it might globally, but there's not like a statute that says this is what custody means. And so when I talk about custody, I say it's the parenting plan. It's what are we going to do and for these kiddos, and how are y'all going to work together for these kiddos? And it is comprised really of lots of different things, but three main areas. And so when you have a divorce, or if you are not married but have a child with somebody or children with somebody, you are going to, and you go to court, you're going to end up with a parenting plan, which is custody, right?
The time schedule. Who has the kiddos when?
Right. And I explain it as there's really three main components of it. There's legal custody, which is what we call under the code conservatorship, which you know what that means, but who gets to decide what legally and how. And then there's the parenting time, and then there's the money aspect of it. And so those are the three main areas. There could be obviously other details involved, as you know, but when we talk about a modification, what that means is that we already have a parenting plan in place. A judge has signed an order that dictates all these three things.
And that could be the divorce decree.
It could be, absolutely.
Or it could be, if they weren't married, what we'd call a suit affecting the parent-child relationship order.
That's right.
It's a mouthful.
That's right. And those are all considered original proceedings typically. And so we already have a judge that has made a decision or signed off on an agreement. And so if we want to modify, we've got to go back to that judge and file another suit affecting the parent-child relationship. But this time we're going to call it a suit to modify that parenting plan.
Gotcha. So we didn't like what happened before, maybe, or we regret our agreement and we say, ooh, I want a do-over. Is it a do-over?
I would have to say no, but that's probably what a lot of people want. But technically, it's not supposed to be a do-over for a couple reasons. One, because if you've gone to court and had the judge decide, that is the judge's decision, and we have to honor that, or based on the facts at that time, or you entered into an agreement and that you were willing to agree that that was going to be in the best interest of your children. And the judge has blessed that and signed off on it and made that the court order. And so it really isn't a do-over because theoretically you agreed to it then, you thought it was fine then. So why we can't do it over unless something has changed typically.
So it's not going to be a week later, like my order has been entered, I say, oh, what was I thinking?
Right.
Or what was that horrible judge thinking?
Right.
And a week later I say, I'm filing a modification.
Right. Absolutely.
How much time would typically have to pass?
Well, yeah, and this is such a lawyer answer, but it depends. But I think anything over a year, there's going to be less restrictions that you have to jump through legally to get a modification, but that's not to say that it's guaranteed. No modification is ever guaranteed, as you know, and there's certain things that have to happen. But theoretically, whatever you were able to anticipate when you made that deal, and we'll just call it that you made the deal, and you entered into that agreement with your co-parent, it has to have not been anticipated, theoretically, whatever the change is. So maybe that's a week later. Very rarely is it going to be, but typically it's going to be a long time later, so when their needs have changed.
Two things you have to show, right?
That's
two
right,
burdens of proof. What are they?
So first you have to show either a material and substantial change in circumstance, and that could be to the children, to the parents, to anything that really affects the child and the child's best interest, which leads to the second prong. It has to be, the modification that you're requesting has to be within the child's best interest. And that's so broad. There are some parameters that we can look at and work at, but it really is, it's pretty subjective in my opinion.
Yeah. So on the material and substantial change, there's not a list, is there?
There's not. This is such a hard question.
And it could be dramatic. It could be a big change. Like if a week after somebody got arrested and they went to prison, that probably wouldn't matter that it was a week later.
That's right.
Because that is so dramatic.
That's right.
But often it's not quite that dramatic, is it?
No, but that has happened before. Right. And that, and that's a good point is when you talk about the time period, I would say the shorter the time period from your last agreement would increase the drama maybe in terms of what the change is.
The change needs to be a little more dramatic.
Yeah, absolutely. And it's not necessarily from the day that the judge signed the order, right? It's from the day that the judge either made the ruling or that you made the agreement, that you went on, which often happens at mediation, often with you, right? But
that's what I like.
Right.
I like it when it's with me.
Right. And so the judge could sign it months after that. That's not typical, I would say, but theoretically that could happen. And so there could even be a change in that period, which gets a little tricky too, but that would again have to be pretty dramatic. But the less dramatic versions, those are going to be what we typically see more often.
Yeah. So give us some examples of what would a material and substantial change be in the average situation. They didn't just get arrested and go to prison.
Right. So, so the less exciting, dramatic ones. For example, the first thing that comes to my mind is the child's needs have changed. So maybe they have now been diagnosed with dyslexia, or there's some sort of learning disability, or they have a 504 plan or something, or the school that they were attending isn't meeting their needs. And so they're looking at other schooling options that are going to meet their needs. And there may be a disagreement there. And we've got all these experts involved in this child's life. We've got a private diagnostician. We've got the school diagnostician. We've got therapists. We've got all these people who are saying and can support this. This child needs XYZ accommodations to meet their needs, and we've got one parent that isn't agreeing, and we need their agreement, or however the order is structured, we're not able to get through to the other side to help this child. That would be a really, really, really good reason to go get a modification, in my opinion, because it's not something that was anticipated at the time. We didn't know that this child was going to have these type of struggles or learning differences.
It wasn't addressed.
Correct. It wasn't even known.
Okay, you made a great point that the other person, the other parent would not agree.
Right.
So your same scenario, child has learning differences. If they both agree and they want to change the existing order, do they have to go file a modification to do that?
No, not at all. And I think that's a misnomer, and a part that a lot of people don't realize is I want the order to say X, Y, and Z, or I want it to do this, or I want it to do that. The order can't accomplish everything. It can't. It really just cannot. There's not a legal resolution to raising a child. That would make it maybe a little easier. I don't know. But there's just not, right? So there's only certain things that a court order can accomplish. But really, and we talk about this too a lot in parenting time, because, well, what if I have I want to go on vacation this week or that week or whatever, I don't want to try to go to Disney World during, spring break or whatever, which is a terrible idea.
Agreed.
Yeah. But I want to go during this 1 week in the summer, but my co-parent has that time, we'll talk to them, switch it out. In our standard possession order in the family code, at the very top of every parenting time plan, there's a paragraph that talks about this that says, at the end of the day, if you guys agree, if both parents agree on whatever time schedule it is, that's sufficient.
Do whatever you want.
Exactly. And I think you've even mentioned this when we were in mediation one time, this document, that's this agreement that's going to be turned into a court order. In an ideal situation, you put it in a drawer and you never have to look at it again. It's like an insurance policy. You only have to pull it out if you need to make a claim, right? Or if you can't reach an agreement with the co-parent. But at the end of the day, that's going to be the best situation. And if your co-parent comes to you and says, I need to switch weekends or whatever it is, it's usually in your benefit too, not just the kids, to work with them, because there's probably going to be a weekend that you need to switch, right?
Yes.
But if you do that, if you're the parent that is wanting to work and being flexible and trying to agree, and the other parent is not doing that, that may even be a reason, I wouldn't say singular, but that could come into play that could help support a modification.
Yes. Sometimes you just have the client who they're just a rule follower and they like rules and they're kind of black and white thinker. And so they want to go by the order and they want the other person to go by the order. And when I say, hey, maybe work with them, they're just like, what are you talking about? We have an order. But it can come back to bite you if you are inflexible.
Yes.
Because they can go to court and say, gosh, judge, I need to change because I can't get 1 inch of flexibility over here.
Right.
Like my sister who lives in Japan is in town on their weekend and they won't let my kids see my sister.
Right.
Come on.
Right.
And the judge is going to agree with come on. Right?
Yep, they are. Generally speaking, I mean, the judge is going to expect there to be flexibility, right? Because again, raising a child it's not that rigid all the time.
Yes.
Right. And so there has to be some of that, which leans into acting in the best interest of the child.
One thing that sometimes people are surprised by, let's say they went through a contested divorce and they did have a trial and the judge did rule. And then later they say, I want to have modification. Sometimes they're like, well, what does that involve?
Right.
It's almost the same thing, right?
Absolutely.
As the divorce. It's witnesses and hearings and evidence and it's expensive.
Yes.
You shouldn't do this lightly.
Right.
You should only do this if you really have exhausted the practical approaches.
That's right.
So what are some practical approaches?
Oh, that's a great question. Well, one of them is using the resources that your order already provides you, which you may not even realize how vast that is. And so going to, we talked about a little bit the legal custody and the legal decisions, looking at that in your order and saying, what do I have the right to do, right? If I do have a concern about our child and the school maybe not meeting their needs, or maybe this child needing some outside influences like a therapy or something like that, what can I do on my own and what will I do to research that, right? And then present the options to your co-parent, right? So maybe it's come to the point where your child probably could benefit from therapy. And you've looked on, your covered providers and you have found, selected 3 or 4 or 5 that look good. You vetted them out and you present them to your co-parent and they've just shut you off, right? They're not listening to you. They're not hearing you. Go away. Our kid is fine. whatever you're saying is not relevant, right? So then what do you do, right? Well, sometimes your order is going to allow you to get them into therapy anyway, right? And so do it, right? There's nothing, if your order allows it, do it. As long as you're telling your co-parent what you're doing, right?
Yes.
And invite them to come along in the process. That is all you can do sometimes because you can't force them to join you, right? But you can if the order allows it, sometimes it doesn't, but you can sometimes do that on your own without having their consent or needing it. Now, that's probably going to be the best value to have before you go to court, because if you come to me or you come to you and say, here's the issue, here's what I have going on, you know, my kid is saying this, my kid's reporting that, my kid, I'm going to say, I can't get your kid on the stand. I can't get that into evidence. I can't do a variety of things to present that very important information to the judge. And that's a hard pill to swallow. I mean, I don't think a lot of people realize that. Wow, really? I thought they did have a voice. I thought they could talk to the judge. A therapist is a great way to get that information into court and have it be heard by a judge. And a judge typically will take a lot of weight or put a lot of weight into what a licensed professional counselor has to say, especially when involving the best interest of children.
Because usually the therapist is not aligned with mom or dad, they're aligned with the child.
Right, exactly.
And judges like that.
Exactly.
They view it as a neutral, unbiased voice. Right. Whereas mom and dad, of course, are biased.
Absolutely.
For themselves.
Yeah.
As one would be.
Right. Yeah, it's definitely a neutral situation. And then, you know, if you are in the point where you've even done that, or you're in a situation because your order won't allow a unilateral decision like that, so you have to maybe go to court to get that, you know, to get a counselor appointed or something. There's also other resources available once you get to court, like to help the child or to get the child's voice heard. But again, you're already in court and spending the money and doing all of those things.
Sometimes there's a counselor available through the school. The school counselor. And even if you can't get a counselor out in the world, maybe your order allows for it, but the counselor says, I'm not seeing the child unless both parents
agree,
consent, which happens a lot.
It does, yeah.
And I don't blame them. They're protecting their own licensure. They don't want to get in trouble, and they think, well, I don't want some angry parent later to say, why are you seeing my child? So some of them have that personal policy, and you can't make them do it, even if your order says, I'm allowed to take them. Right. But the school counselor will see any child in the school.
Yeah, that's a great point.
So you can always call the school and say, hey, this is what's going on. I'm worried. And that also would show the court that you did have concern.
Yes.
You weren't lying behind the log, so to speak, waiting for your modification a year later and then saying, you won't believe what he or she did a year ago.
Exactly.
And my child's all screwed up from it. Well, what'd you do about it?
Right. And that's a good point, because it's very difficult to complain to a judge about something that happened so long ago and expect there to be this miraculous change when you didn't even take the resources available to you to at least try. Right?
It doesn't make you look actually concerned about it, right? It makes it look like you're just looking for bullets to shoot at the other parent.
Yep.
So I'm with you on, hey, what are you doing practically?
Yeah.
Some existing orders have a parent facilitator or a parent coordinator appointed in their existing order, their divorce decree.
Right.
So what is that?
So a parent facilitator and parent coordinator, they do essentially the same thing. Well, they do the same thing, but it's usually it's either a lawyer or a mental health professional who's been appointed to assist the family when lawyers are not involved and there's no pending lawsuit, and it's somebody that you can go to and you can meet with, whether it's individually, together. You can air out grievances and say, you know, I don't like the way that my co-parent is doing X, Y, and Z, or here are the issues that I'm having with whatever's going on with our child. Here's the proposals I've made. Here's all the counselors I've, suggested, and my co-parent just is ignoring me. And then the parent facilitator may walk through all that and help them get to a point where they can at least reach an agreement to say, okay, well, co-parent, B, you're going to take these 3 names that your other co-parent has given you and research them, and we're going to meet back again and, reconvene on this. But it's somebody who can help them through the process, and that's just one example. It can be a variety of things. But the biggest difference between the two is a facilitator can testify in court, and none of it is confidential, whereas a coordinator, it's all confidential. And so sometimes it just strategically, you have to determine with your lawyer which version of that you want to include in your order, or the judge is just going to appoint one, right?
Yes.
In that case, but
yes.
But that can be pretty valuable too. And a lot of people will say, well, it's just one more person I have to pay, but it's not a lawyer you have to pay, and it's not a lawsuit that you have to go through, and it can be less stressful. And then if you are in a position where you do need a modification, you have all of this evidence essentially to back you up.
Yes, and it's as needed. So it's not like they're going to the parent facilitator if neither of them have an issue. It's when we had a fight about Easter and the order isn't clear because this year Easter conflicts with spring break or whatever.
Right.
That kind of thing. The orders cannot address everything.
That's right.
We don't have a crystal ball about the future. So sometimes it's interpretation of the order, or the order just doesn't address it. There's a little hole.
Right.
And that needs to be worked out, and they can talk with that person. They're a facilitator, basically.
Right. Yeah.
But I do like the parent facilitators because I like that they can testify.
Yes, same.
There are situations where I think my client might not be the one that looks so great.
Yep.
Just because of a personality, maybe.
Yeah.
And then I'd be asking for a parent coordinator because I want them to get the help. Right. But I don't want them to harm themselves by the evidence this could create.
That's right. Absolutely. And that's really the biggest difference, I think, in those two. And why, as lawyers, we use them in those ways.
But I found people come to me for modification, and I say, do you have a parent coordinator or parent facilitator? They're like, I don't know. And I say, well, let's look at your order. So back to your point, look at your order. Maybe it's already in there, even if you never went to them.
Right.
Because neither of you wanted to spend the money. But maybe it's a resource that you have before you go and file a modification.
That's right.
So sometimes people are preparing for a modification because they didn't like the order to begin with. It was imposed upon them by the judge, or they regret the agreement they made. So they know someday, my child's 3, we have to get to 18. Someday somebody's going to file a modification.
Right.
What would you advise somebody to do for the preparation? They're not going to file tomorrow. It's going to be a year or more from now, but they want to get as much good evidence as possible.
In writing. And I say that because there's so much of that now with texting and email, and it's a lot easier than I think we think to capture all of that, but document. But how do I do that, right? Well, you want to do it in a way that if you do go to court, it's easily digestible for your lawyer, for the judge, for all of the people who are going to be making these decisions and having to digest, whether it's 1 year, 2, 3, however many years, right? And so text message is a great thing. You can download those. There's tons of different softwares and apps that you can do all of that, and it'll, Control F if you're looking for certain words, but, keep a calendar, keep like a diary, right? Dear lawyer, whoever that is going to be, right? You walk it through all the issues, the things you've done, how they have responded, things like that. There's also a lot of great tools that might already be incorporated into your parenting plan, or that you could propose to your co-parent. Our Family Wizard, there's one called Close App, or App Close, I don't remember which one it is, but some of them are free, some of them you have to pay a subscription, but it's basically an online parenting app where you have all your communications. It's downloadable. It's super easy to look at: calendars, notes, journals. You can upload receipts, things like that. Spreadsheets are really great too, if that's something that is a part of your case, whether that's money exchanges or things like that, what you've contributed versus what they've contributed, if that is an issue. I don't think you should necessarily nickel and dime every expense, but if that is something that is relevant in your order, and if you need that to prove, then to have that. But just document.
I love Our Family Wizard. You can invite your lawyer to view it, and the paralegal can just download stuff from it. I also wonder now, with the concerns about deep fakes, if you would have a higher chance of it actually being real coming out of Our Family Wizard. Might be easier to deep fake a text chain, for example.
Yes.
And explain what I mean by a deep fake.
Well, if I can go back to the text messages, it's a really good point you made, because this has happened to me in a case, is that some of those applications, they're not perfect, right? And where we've pulled those messages and we've produced them or something, and it's missing like gaps of messages, or the issue with deleting, right? Some of these phones can do that now. Whereas, and that's a great point. Our Family Wizard has, it's not going to be manipulated, right? And I have an attorney login where I go in and I can view it, and it doesn't even show, and I'm sure you have one too, where it doesn't even look like I'm in there.
Right.
Because it does have a log of when each parent logs in, views it, looks at it. You're not going to necessarily have that with text messages either.
Right.
Or emails.
I have used effectively in court. I had Our Family Wizard. One of the issues was one parent will reach out and the other parent would not reply, right? And it's something medical about the child or a decision they need to make. And what's great about Our Family Wizard, it not only shows when they replied, it shows when they opened it.
Yep.
So that person didn't open it for like a week.
Right.
And its subject line is medical issue.
Right. Urgent.
And that was very persuasive to a judge that, hey, this person won't co-parent to the point that, my client's having to text and say, check your Our Family Wizard. You can set up the Our Family Wizard to alert you that your other parent wrote something. So it's not like you have to log in every second.
Right.
But that was really effective. So I do like that tool, and it's a good planning tool. There's not, my phone went in the lake and now I lost all my text messages and I don't know how to retrieve them. It's going to be there. Now, sometimes our clients need a little coaching that the Our Family Wizard message is actually beneficial to them. Yeah. They should not, in that form or any format, say a bunch of horrible things. They don't want to be Exhibit A.
No, never.
Like, read Biff.
Yes.
By Bill Eddy.
Yes.
Great book. And write the horrible message. Just don't send it.
Yes. And that book, I recommend to almost every client, especially those going through a modification or some sort of custody issue. And it stands for brief, informative, friendly. I forget what the other firm. That is literally the only way to respond. And that applies to many things in life. But read it, whatever you're writing, read it, as though the judge is going to read it or whoever is going to read it, or it's going to be published somewhere. And really we should be doing that anytime we send any type of written communication. But there's no reason to go into all of your grievances or air all the bad laundry. There's a reason why you have an order in the first place and you're thinking about modifying it. Just remember that and don't get up. You don't have to try your case in the Our Family Wizard messages.
Right. I think people sometimes over communicate.
Yes.
So we talked about under communicating and not even checking it. But sometimes once they've already had the discussion and it's clear where everybody stands, we don't need to keep having it. So it helps if you're going to modify someday. Right. Pay your lawyer a little bit of money to just look at some of your correspondence and make sure you are writing appropriately in a business-like manner and not making yourself look bad by either saying it 10 times more, telling the person they're a horrible person, they're a horrible parent, how dare you, blah, blah, blah. None of that.
And I can't imagine you've never ghostwritten for a client before.
Oh, right. I'm like, how about if you said it this way instead? It's just coaching.
It is. No, it's
and once you do it a few times, then they get the idea.
Right. And if your lawyer says, read the Biff book, and I think Melinda and I are both saying, read the Biff book, do it. I mean, I have it in my office, and I'll look at it, from time to time. It is invaluable.
I even have clients who will say to me, I know this wasn't very Biff.
Okay, so at least they read it, right? No, and they read it. But that's also something interesting, too, that maybe going back to how you can prepare. If you are having complaints about your other co-parent, what are you doing to, better yourself, right? Yes. And because if I get your co-parent on the stand, maybe I'm going to confront them with these messages and I'm going to ask them, have you ever heard of this book? Have you ever read it? What have you done to, help with this or whatever? And I want my client to be able to say that they've done all the things that I've just chastised the other, party for not doing. But it's, it's about you too and what you can do. You can't control the other person at all. But you can. So you have to be able to, I would love for every client of mine to be in a position in a modification where they have exhausted almost every avenue possible.
Judges like it. They like it.
Yes.
Jessica, you said you're in the Collin County office.
Mm-hmm.
We're going to put your contact information on the screen. Do you practice outside of Collin County?
I do. I'm primarily Collin County, but the surrounding counties, Dallas, Denton, a little bit of Tarrant, which is also really helpful because we've got offices in all those counties. And so if we need help or, I know someone, one of my partners goes in front of this judge a lot, let's talk to them about X, Y, and Z. And so having those resources is really helpful.
Thank you so much for being here. You've been great.
Thank you. It was fun.
Thank you so much for tuning in to the Melinda Eitzen Show. We'll see you next time.